Much like Judge Chu said, family law is a very specialized area with a really large family code with case law that changes pretty frequently. So I'm only going to touch very briefly on the property issues. Basic logic, a divorce is pending, a spouse passes, the divorce ceases to be. And so basically I would be sending this over to all y'all probate attorneys to take this up to Judge Chu. Death during an appeal, if the spouse does die during an appeal, it technically goes away unless the death affects the property rights and that division. So if the property was divided in a certain way and that is being appealed, it can still go up on appeal, and then probate again will make certain decisions afterwards. Spousal support. The death of anyone, any spouse, terminates the obligation to pay spousal support. It does not terminate anything that has been past accrued if you fail to pay. So again, that would be something you could collect from or buy an estate. And that would again be a probate issue. Basic rule, when a parent is, I'm not sure why it's, when a parent is obligated to pay child support, it does not end when either parent dies. So what that means, y'all can read the statute. I'm not going to read it to you because actually I don't like when people read slides to me. But the basic gist is if an obligee, which is essentially the custodial parent generally, it might be a non-parent, of court-ordered child support dies, the obligor, the person with the duty to pay support, does not terminate. The party who then takes possession or custody of the child can present that obligee's death certificate and ask the court to redirect the payment. There are several statutes that go into great detail about how you do it, but that's the general rule. Child support, death of the obligee, again, the person who's entitled to possession of the child. It is important to know, and this is a pretty big case, and it does come out of El Paso. One of the things about family law, which I'm sure is very similar with probate or other areas, is different jurisdictions do different things with the exact same fact scenario. So these are very fact-specific things. However, in this case, I did want to point out is often child support orders in our decrees are partnered with life insurance obligations to secure the child support in the event that obligor died. So that obligation remains even if the obligee dies. This is if the person who is obligated to pay child support dies. Effectively what happens is an acceleration of child support. That estate would have to pay out whatever the 5 years are left or the life insurance policy if it was court ordered to maintain that child support obligation. And although this may be obvious, the death of the child terminates that obligation. However, again, much like spousal support, it does not terminate the obligation of any retroactive child support that either is due or already has accrued in a judgment. So I kind of wanted to focus on the issues of custody more, which I think are, at least in my mind, some of the most important things going on right now. The general rule is, this applies to pending divorces, post-divorces, modification, any stage of the case. What this means is an absent parent who has no relationship to a child can step forward and is de facto entitled to possession of the child, absent other court orders. Most commonly what would happen is, let's say a father who has been excluded from their mother's life and the mother has passed away. They would come to me, we would file a habeas corpus, and we would get possession, which you're entitled to as a matter of law, by the judge. It's a basic, almost ministerial action unless you can file some other things. This becomes very complicated. The law is very specific on this, so there are some caveats in this area. Now, the caveat to this general rule is if you have standing. So these are some mechanisms. These are the next one. These are some of the Texas Family Code provisions that govern whether you can step in and try and get custody of a child. This would allow grandparents, step-parents, relatives, but remember, this just gets you through the door. You still have to overcome the parental presumption, and I'm sure most of you know, but just for a quick detour, In 2000, when the Supreme Court decided Troxel, which is basically our 14th Amendment guarantee that we get to parent our kids pretty much how we want to, absent us not taking care of them. So the general rule is we presume it's in the best interest to appoint a parent, and then if it's a close call, it definitively goes to a parent. So I've always suggested that you can plead more than one, hedge your bets, because some of them have different burdens. General standing. So this is 102.003, 9, 11, and 13. These scenarios are very fact-specific. For every case that I can tell you that a step-parent caught custody, I can give you another case in Texarkana where they didn't. So these do require that the person seeking custody have taken on a role of loco parentis. It does not mean that the custodial parent has to have abdicated all parenting responsibilities or legal parenting responsibilities. This allows partners, same-sex partners, step-parents, arguably roommates and nannies, if you could meet it, to meet this burden. Any questions on this one specifically? I can go through and maybe just raise your hand if you want to interrupt me at any time. The requirement under number 9 is, there's a case on point here in 2018 that really talks about what it means to have actual care, control, and possession. These are the basic nuggets that I've kind of put up here and interpreted. There's no requirement there be legal custody or legal control, no requirement there be a power of attorney, a guardianship, anything like that. There's no requirement that that non-parent have exclusive control. It doesn't have to be continuous either. If you take on the responsibility that a parent takes on, deciding bedtimes, deciding helping with homework, all of those things, that can put you in the role. If you're making those day-to-day things that we make as parents, that can put you in. So, and it doesn't mean that the non-parent is not still, the parent is not still exercising control. You can share it. Resided together. Resided together does not have the same legal connotation as residence when you see it in most codes define what residence is. This is what's typically called the step-parent statute. And the Donsor case is a case on point. Came out, Justice McClure is the one who wrote this opinion. And in this case, there was a mother. She had, quote-unquote, primary custody of her child. Dad dies. Stepmom steps in as the non-custodial partner and says, this should apply to me too. I want custody. And that's when it was basically decided that the technical definition of residence is living together, and she did. Grandparent standing. This is a different statute, and I'm going to be honest, sometimes grandparents probably have a better standing if we're talking about the scenario that we're seeing right now under the 102, because there's a specific provision that says if a parent is dead, then if you're related within a 3rd degree of consanguinity, you get in. You get in the door, you get standing. And so it's a pretty big burden. All the cases quote Troxel. All of them say that the presumption to overcome a parental presumption is very high. Even if it was a parent who's been absent, never stepped up, never done anything, never paid child support, they still get the presumption over a grandparent who may have been the daily caretaker. It's a very narrow inquiry. Everybody hears about best interest. This is much narrower than that. And you cannot meet your burden by just showing that a non-parent would be a better custodian, or that they have a stronger ongoing relationship, or that the parent hasn't been a great custodian. You really have to show that there's a significant impairment to the physical health or emotional development. It's a very high burden. Sibling statutes. So there's case law that deals with CPS cases and siblings, and there's very little case law that deals with separating siblings, and it's mostly in divorces. However, the Texas Child Welfare Bar and the Supreme Court there has taken a stance that there is a fundamental right that siblings have to remain together. So, I would argue, and in fact there is a case, and I'm drawing a blank on it, there is a case out of Oh, actually, the U.S. Supreme Court, in their dissent in Troxel, said this, which I think is a pretty powerful statement. While the court has not yet had occasion to elucidate the nature of a child's liberty interest in preserving established familial or family-like bonds, it seems to me extremely likely that to the extent parents and families have liberty interests in these intimate relationships, so do children, and their interests must be balanced. Our prior cases recognize that children are, generally speaking, constitutionally protected actors, and this court rejects any suggestion that when it comes to parental rights, children are chattel. So there is a statutory preference. It's not a burden of proof, but there is a preference for keeping them together. And I talked to it, there's great case law talking about it not being presumed, but I would say that you could try and argue it would weigh in your favor if you had, as there is actually today in El Paso, you had one parent stepping, or one proposed custodial person stepping forward who only wanted one of 3 children, and another parent who wants all 3 children. If I were representing that person who wanted all 3 children, I would argue definitely that these siblings have a right to be kept together. And then when both parents are deceased, then it's a pretty broad best interest standard. There is a suit for possession of or access by a grandparent. Let's say a grandparent's child has passed away, and that's a requirement on one of the sections. Let's say the parent, one of the parents has passed away, and the grandparent of that parent wants visitation, and now the single parent is not allowing. This is a provision that you can use. It is extremely hard to get. I think you're better off going under a custody request than you are under access, because first of all, you have to show that the parent is denying the grandparent access, and then you also have to show that if denying the access would significantly impair the child's physical or emotional well-being. Again, a really big burden. And the Troxel case is quoted over and over in these cases. So you all think at this point there's no way that anybody who's not a non-parent can really get in there over a parent. That's not entirely the case. There is an interesting delineation. There's a case here from the Supreme Court of Texas called In Re VLK. And in this case, they have decided, and the analysis is worth reading, that there's no parental presumption if you're in a modification. So that means if you are modifying, if there's already an order out there and you're coming in to modify and try and take custody of this child, you don't have to meet that Troxel burden anymore. It's a standard best interest standard, pure and simple. So that may work really, I mean, a lot of us already have existing orders. That may be a way for a non-parent or a step-parent or whoever to come in, and it can make your case a whole lot easier. That's my information. Is there any questions? Yes, Steve.
You did great considering you just started last night. I know that. You went into a lot of detail on family law, which could be intimidating to somebody that doesn't practice it. However, the forms that you use would be a petition, for almost all of this, a petition for a suit about family relationship and a petition to modify. And I think they're not that hard forms, and I think they can get that for you or for me. It might make it a lot easier.
Absolutely. One of the things is, as I said, the case law is so different in different places. There are many folks who think, okay, I'm going to do a quick, easy divorce or modification for my cousin, and they come in and realize it's a lot more complicated than you would think, because certain things require affidavits. For example, the affidavit is required to allege that it would significantly impair the emotional or physical well-being. Those are often forgotten. So absolutely, we can always share the forms, but you will have a family law attorney who will knock you out on a technicality if they're not done completely right. Yes?
If a child dies, can a custodial parent posthumously move for enforcement of a previous thing for back support?
Absolutely, okay. Yes. They are effectively a trustee for that obligation. So if the child's died, anything that was past due still remains due, and the statute of limitations on that still apply. Yes?
You have a couple cases I put in Ray HS case.
I do with me. I just didn't bring it. Like I said, I kind of put this together really fast. So I kind of threw out the big ones, but I can get it to you. Yes? Can you speak up just because it's super hard to hear you?
Do you mind sharing your PowerPoint presentation with everyone?
Absolutely. Yes?
Is there anything that us non-family law lawyers can help? Because obviously, you know, the picture I got it's pretty daunting. So, or is it something best left to the family lawyers?
As a general rule, just like I would never do a probate case, I would never do a criminal case. I only do family law. That's always, that's usually my preference. The problem is, let's say you're representing a non-parent, and there's a father who stepped up and wants custody of that child who has not been in the picture. There are so many little things that you have to check to meet your burden of proof to get into court, and once you're in court. So that's the only caveat I would say. Because you have to go from one code to another. This code may apply, that code sometimes doesn't apply. Thank you so much. I had asked if I could, I had hoped to have, Linda Rivas, who's the director of Las Americas, had wanted to give some information. She is helping the Remain in Mexico clients, but Melissa's here from DMRS, and I'm hoping you can maybe elaborate a little bit more on the U visas, which I think are really important, especially for some of your lower income clients. So I'm giving back some of my time to her.
Thank you, Lyda.
So in terms of the U visa is a benefit that was created by Congress that provides ultimately legal residency, immigration status for anybody who is the survivor of a crime. What's going to be a little bit difficult in this situation is those people that were killed are obviously victims. Those that were shot are obviously victims. What's going to be a little bit more difficult and more complicated are those victims that were in the Walmart at the time that it happened, but perhaps didn't see necessarily anybody get shot. So we're trying to figure out some of the legal issues involved in the U visa. But as a general rule, I think anybody who was in the Walmart at the time of the shooting should, and is undocumented, should speak to an immigration attorney. One of the things that we've encountered up to this point, I think we've collectively spoken to maybe 50-ish people. A lot of people are not concerned with wanting to stay in the United States, and that's the whole point of the U visa. So if somebody has no interest in coming and living in the US, we would not pursue a U visa for them. But I think it is really important to have that conversation with people now. If this is something that they might be interested in the future, it's critical that they get in touch with law enforcement because they must be listed on a police report. The police, the FBI, some law enforcement agency must have had communication with them. So it's really, really critical that they do that.
Do they have to actively be assisting with law enforcement in their investigation?
They had to have, the way that the statute reads is that it has to be, you've already provided assistance, you are currently providing assistance, or you are likely to provide assistance in the future. So somebody who's already spoken to law enforcement and given their statement arguably qualifies for a U visa because they've already been helpful in the past. But the law enforcement part of it is critical because when we're filing a U visa, we have to get a form signed by law enforcement that says if this person has been helpful. And so if they have not had, we've had multiple meetings with the DA's office, we just met with them this morning, and they were very clear, if they do not have contact with law enforcement, they will not qualify for a U visa. One thing that you do need to know about the U visa, there is an annual cap of 10,000 U visas that can be granted per year. There is currently a wait of more than 100,000 applications, which means that even if somebody qualifies and we file their application today, they may not get a U visa for 10 plus years. And that's probably being conservative. So, a big part of this is going to be setting reasonable expectations for people as they consider some of their immigration options. As I said, up to this point, most people have no interest in staying in the U.S. We've had several people say that they feel more safe in Juarez now than they do here in El Paso, which is, I think, a true testament to how how impactful this event was on all of us. I think we're all feeling that. And so they're also dealing with the uncertainty. A lot of them are dealing with losses of family members, of severe injuries. And so what's just really important is that if there is anybody that was at the Walmart, even if they don't think today that they want a U visa to be in the United States, we should still put them in contact with law enforcement. And we have contact information for all of the different law enforcement agencies, both federal and state. And I have been personally assured that neither the state nor the feds will be taking any sort of immigration action against anybody, so they can come forward comfortably without having, and we're happy to be there with them just to ensure that nothing happens. The other issue that's going to come up is border crossing cards. We have a lot of people that travel regularly into the United States and use their visitors visas to cross. There are people who are here shopping for school supplies and then planning to return. We had 8 Mexican nationals that were actually killed. So that's another issue that might come up. Somebody that wants to participate with law enforcement, but their border crossing card expires. We had a very close family member of one of the people that was killed. Their border crossing card was going to expire days after the shooting, and we were able to get them in touch with the people to get it expedited, the renewal expedited. So there's a lot of issues that people are going to have, and not necessarily because they want to stay here permanently. They just want to be able to come to court and participate in the court process. Some of these issues will come up for them.
What about caretakers? Because I understand that some of the people that are still recovering are long-term, they're months possibly in rehab, et cetera. So they have family members that need to accompany them and be with them. Is there something that can be done for them?
I think so. Every case is going to be a little bit different. It's going to depend on the person's immigration history. How, if they've been deported before, then that obviously changes the conversation. How close a relationship they are, the extent of the injuries. I will tell you that up to this point, at least, most of the federal agency that most controls that is Customs, so the bridges. And they have been very helpful up to this point. So I think it will be possible to get them extended permission to stay, but they need to be in touch with an immigration attorney, especially if they've had prior contact with immigration, because what we don't want them to do is to go present themselves at an immigration office and then have something outstanding that could come back and hurt them.
Is there a time limit that the people who were there at the Walmart, like a time limit to reach out to law enforcement? Because obviously by now it's been 19 days.
Yeah, that's a question we asked them today. What we're being told is pretty much up until the point that the case is done, that people can still come forward. But obviously, I think the longer they wait, the more questions it raises. And so it's better to be in touch with law enforcement, give your statement, give your information. And then if you decide to pursue it, you can pursue it a year, 2, 3 years from now. But the most important step is to come forward and have that conversation with law enforcement. And initially the police department was turning people away, and they were only speaking to people who actually saw the shooter or who had actually been shot. That's not the case anymore. They are now widening that net of people. So for example, I was telling somebody, I was driving past in front of the Walmart as it happened and saw a whole bunch of stuff happening. And so they said, we actually might want to take your information down. And I'm like, well, I wasn't even there. I was just driving past. They said, well, you may have seen